if it turns out that perhaps you too have unfortunately come across this particular type of litigant every so often, what I'm about to say may not be much of a surprise. And it may be that I don't actually tell you anything that you don't already know. But at least we have the advantage of having something approaching a counselling session in this beautiful environment that we have. So, what do we have? You see the ET1, which is unfocused, is wild, is hopelessly inadequate, and you know exactly what you're going to spend the next 3 years of your life litigating. So, and your first instinct as a lawyer is, of course, that the pleadings are unparticularized. Right, I want particularized pleadings. I want to know the case in proper detail before I do anything. And of course, 9 times out of 10, that will probably be the right approach to take. But I'm a great believer in keeping your powder dry, because if your first instinct is to look at an unfocused set of pleadings, it may be that the tribunal, when they get to case management, share the same instinct. And if so, you might save your client a little money, you might save a little time, and you might save a lot of personal stress than trying to get an unreasonable litigant to particularize a claim in advance. And of course, what you don't want to do is make the other side alive to the weaknesses of their case at an early stage, because of course, the earlier they get their ship together, the earlier it is, for the purposes of any amendment, the more prospects they have of actually getting any amendments in. So in terms of whether you actually ask them to get their case in a ship-shape manner or not, I would ask you to urge on yourself a little caution. Just hang back, because if you end up in a case management situation where the tribunal is trying to identify what the case actually is, that will put pressure on the other side. But of course, there's a balance. Don't let the tribunal write the amendment for the individual. And remember the basics. An application to amend must be in writing. It can't be done on the hoof. So if you're in that case management hearing and the tribunal are trying to sit down and work out what on earth this claim is about, remember to remind the tribunal not only that they are not there to write the amendment themselves, but if what we are doing is actually amending the claim, such an amendment has to be done in writing. It's a simple thing, but can sometimes get lost in the heat of the application. And timing is crucial, because we're all familiar with the Sell-Kent principles, and we are all familiar with the principle that the later the amendment, the less likely it is to succeed. So again, I'm sure you will know this instinctively, but chronologies in that respect are very important. And also another point to bear in mind is that when you're there in the case management hearing and suddenly you're taken by surprise by a wholly new type of claim, and then the litigant will be asked, well, where do you mention that in your ET1? If there is a nebulous reference to it, if there is only a vague reference to it, always ask yourself, is that enough? Because there's one case there, Foxton's Limited and Rule, where there was a hint of what might be sex discrimination and what was otherwise an unfair dismissal claim. There was talk about comments made about the claimant's manner of dressing. There was mention of bullying. But the approach of the tribunal was, well, that's simply not enough. If you are simply going to aver facts without more, that's not going to be enough. If you are seriously wishing to pursue a sex discrimination claim, what you've got to do is not only identify the facts that you rely on, you've got to identify the causal nexus which gives rise to the claim of sex discrimination. So merely referring to acts which might amount to discriminatory behaviour in a claim form is not enough to say, well, this is just relabeling. It is actually takes it into the realms of this is a new claim. And if it does, you're in a much stronger position in resisting that amendment. Again, we all know the Sell-Kent principles as far as whether the matter is out of time is concerned. I know tribunals will focus on it and will often refer to it in their judgments. Don't hang your hat on that particular argument, because there has been an increased tendency of the tribunals recently to say, well, yes, on its face, it may be out of time, but that is a matter we can deal with at the hearing in the same way as any other issue about whether matters are out of time or not is concerned. So yes, it is important, but don't put too much store on whether it's out of time, because there is a way the tribunals, if they are so inclined, might want to use that to get around. There is also the tantalizing prospect of striking out and deposit orders. We all know how difficult it is to strike out discrimination claims. Hence, my suggestion is focus on deposit orders. Instinctively, you will do the two things at the same time. But if you can just carefully present your case, perhaps on the basis that this is primarily an application for a deposit order, but depending on what comes out of the application itself, you reserve your position as far as the strikeout is concerned. Because then it immediately gives you the credibility of realism. Because the tribunal's instinct will not be, oh, this is a strikeout, we've got to jump through various hoops, this is going to be a lot of work, and ultimately the case will proceed. But if you frame it as a deposit order, my experience has been that tribunals are much more inclined to look at it carefully and take your application more slowly than they would otherwise with the strikeout. And of course, if under gentle questioning from an employment tribunal chairman, you listen to the claimant and thinking, this is getting worse for the other side, that gives you the opening to say, well, in the light of what we have heard, in the light of the claimant's inability to particularize this part of his case, you may think, madam, or you may think, sir, that actually in this particular case, the grounds for strikeout are met. So again, that kind of very reasonable approach in the face of unremitting unreasonableness is something which may, certainly when you're presenting yourself, may give you substantial amounts of credibility. The other point to make, and again this is self-evident, is if there is a core factual dispute, the way to deal with that is simply to consider, well, let's take the facts pleaded by the claimant at their highest, and we still say there's a little reasonable prospect to success. And that's the only real way to sidestep the issue if there is a core factual dispute. The tribunal, of course, will try and step away from any dispute as to the facts. But if you do have contemporary documents which actually clearly contradict what is pleaded, that is something that there is authority to the tribunals to say that they are entitled to take into account. But we are perhaps all familiar with the knee-jerk reaction of the tribunal to say, well, the documents may say one thing, but there may be an explanation for them. The other point is don't overlook the inquiry as to means, because this is sometimes a sore point as far as the other side are concerned. Often you will be met with blank assertions of impecuniosity. But again, I always think it's always worth just inquiring a little into the claimant's background. Sometimes you may get information from colleagues that he or she have been talking about alternative sources of income. An internet search is obviously quite useful in that respect as well. I had one case where someone turned out to have a master's degree in business administration, was actually a private landlord. So all that kind of thing helps. And those kind of situations, you may have a position where they actually frankly refuse to engage with the tribunal's inquiry as to means. And that can speak volumes. Lists of issues. Again, in advance of the first hearing, you will dutifully do your list of issues. You'll send it to the other side, and you'll probably get something which is unrecognizable coming back at you. My advice is hold your fire, because certainly if your experience has been anything like mine, you will send in your list of issues. The tribunal won't have read it, and they will go ahead and do their own list of issues in any event. So again, if you can hold your nerve, as it were, as far as a list of issues are concerned, and let it all out in the case management hearing, that might just be your best tactic. I came across a good quote that's useful. It's a case of actually Gale and Sandwell, West Birmingham. And the comment was, parties must keep a proper sense of proportion in the issues raised for the decision, in the selection of legal points worth taking, and of relevance in the quantity and quality of the evidence they need to call. So it's very much the language of the overriding objective, but again is more specific than perhaps you could rely on as far as the overriding objective is concerned. And again, something to just keep up your sleeve in terms of ammunition. Bundles. Now, this may be your worst nightmare. Again, can I suggest if you were able to take ownership of the bundle, at least you'd have control. And at least you can then put together a core chronological bundle of documents, even though you know there's going to be late disclosure, even you know it's going to be unfocused, and you know it's not going to be properly organized. At least if you can keep a core chronological bundle of documentation, that may certainly assist counsel in the terms of presentation of the case, because sometimes I've found that as long as you have that core chronological bundle, that will be where the tribunal is instinctively drawn to, and sometimes, just sometimes, all that late stuff you get 2 weeks before or a week before can be overlooked. And I don't think a tribunal can criticize you for not trying to chronologically put it into the core bundle if it becomes late. Because certainly my experience has been there is little, if no prospect of writing to the tribunal saying this is too late, we're not admitting it. I'd be amazed if you even got a reply if your experience was anything closer to mine. So my suggestion is, if there is late stuff, let it go in at the back and see what the other side do with it in terms of, and see, you'll want to consider whether even it's admissible, even whether it's worth arguing, or whether we just get on with it and see whether it just gets ignored. So again, it may well be your only tactic here is to try and take ownership of the bundle, and at least you can keep some control. Because that leads on to the next 2 points, your chronology and your reading lists. Try and use these documents to actually guide the tribunal through the material. I try and regard these particular documents as pieces of advocacy in themselves, because you may have a bundle which, through no fault of yours, is unfocused, is not properly structured. But if you have a chronology which references the key documents from your perspective, and if you have a detailed reading list which chronologically handholds the tribunal through the documents. Before I even open my mouth, the tribunal hopefully have got seized of the important points that you want to make, because they will be there in appeal decisions, they will be there in the reasons for dismissal, etc. And when I say a detailed reading list, I don't mean a voluminous reading list. I mean taking the tribunal to specific parts. You may have an appeal transcript which goes on for pages and pages and pages. Try and focus it so there's just 2 or 3 pages which you think are important, because it's the only time the tribunal will have peace and quiet to actually read and absorb documents, rather than looking at documents when you're cross-examining. They look at them necessarily briefly. They're trying to make notes at the same time. Sometimes points get lost. So use those documents as pieces of advocacy. And so my final topic is costs. I know it's a bit of a seesaw in the sense there will be times when you think, why do I even bother making costs applications? Other times you may be quite keyed up and achieve some success. My experience has been, as the time has gone on, and I've been doing this for more years than I care to imagine, tribunals are much more open to costs orders than they ever were before. And this is where your bundle comes in, because even though you may have other points about unreasonable conduct, etc., if you have that key little bundle of abusive or unreasonable correspondence, within 5 minutes, you've already set the tone, and the tribunal will have seen it many times before, and before you need to go any further, they already know exactly what kind of case this is. Your cost warning letter, try and send it as soon as possible. I would suggest after the witness statements. If you leave it too late, you'll be accused of it simply being a tactical ploy where there was no realistic prospect of the claimant withdrawing. So the earlier the cost warning letter, the better. And keep it general. You don't have to be too specific, because if you're too specific, you may end up losing on certain points but winning overall, and that undermines the effect of the cost warning letter. But yes, as far as substantive issues and costs, harassing correspondence, lies, we all love lies, Cairns and the Wellness Zone, that was a personal fitness trainer. Read that, the references in the document. The claimant was clearly having a field day. The tribunal were especially concerned about this distraction technique that she was adopting by giving, and again, forgive me if this sounds familiar, long rambling answers which didn't actually directly deal with the question. There's some great language in there, so go and check that case out. Motivated by illegitimate reasons, spite, unreasonable refusal of offer to settle. Yes, be careful with that. It's not clear cut, but if the offer to settle is made in good time, you will be on strong ground. And ultimately, the litigant who sticks his or her head in the sand, despite you very gently pointing out the weaknesses, this is all fertile ground for costs. So be of good cheer. You may go through a considerable amount of angst to actually get to that hearing. But once you get to that hearing, you've got everything to play for. And I would certainly encourage you, if the claimant goes down like a burning aeroplane, to certainly consider costs. Given all you've gone through, it may not succeed, but will make you feel a whole lot better when you send that letter.